turn first to the central legal question which was at the heart of this debate. Whether giving reservations to the general category on economic criteria is violative of the basic structure of the Constitution. The court has said no. Aman, Lekhi, do you agree with what the court has said, with the majority judgment, or the minority judgment which believes it violates the right to equality? You've kept the poor among SC, SC, OBCs out. Upper caste poor will now get the benefit of reservations.
Well, I don't agree with the majority judgment. I haven't had occasion to read the judgment, but on principles, I think it is flawed. And there are three reasons I give for that. One, if the permissible classification is economic, to deny entitlement to a similarly situated individual on the ground of class will paradoxically itself violate Articles 15 and 16, which is untenable, firstly. Secondly, insofar as 16 is concerned or 15 is concerned, we deal with classes. What the amendment talks is sections. The class and section are mutually distinct, and the class which is in contemplation is one which is in some way disadvantaged because of the historical injustices that to suffer, as a consequence of which it is seen or perceived as one not to be included in the milieu of development. Now, this particular requirement of class, which in some way unites those entitled to benefits in the 15 and 16, would be absent across the elements of the sections which the 103rd Constitutional Amendment deals with, because insofar as the political, cultural, socio-historical conditions of those individuals are concerned, that will vary across. And what is actually contemplated with the Constitution is a horizontal, insofar as classification is concerned. A stratification is not horizontal, but in fact it is perpendicular, because there is a superiority, inferiority over there, which is actually absent in this particular scheme of the Constitutional Amendment. Third, as I feel, which you actually pointed out, the reservation has existed initially, when we talked caste-based reservation, privileged a particular kind of discrimination, and in fact there was a race to show that we have, that insofar as those entitled to reservations are concerned, are backward classes or scheduled castes. We had various instances of people claiming to be so. So it's privileged being a subordinate. Now this will cause further disruption, because as far as entitlement is concerned, the economic criteria would be one again more or less disruptive, where people will actually move towards actually ensuring that they are economically deprived. And the reason for this is essentially the politics behind this entire mechanism, which leads to a bit of rent seeking where the system is concerned, because rather than working the system and improving the education infrastructure, or in fact working upon the representation as such, by reason of these SOPs, gateways are created which got nothing to do with development, which is fundamentally wrong, in my opinion, should not, and which the Supreme Court.
So you're saying it is fundamentally wrong to have brought in an economic criteria. You've made your point. You're saying it is fundamentally wrong to have brought in an economic criteria when the original criteria was social and educational backwardness. Now you brought in an economic criteria which is liable to be misused in some form. Shadhan Parasar, do you agree with that? There will be those who will say at the end of the day, the poor, if I am from the general category and I come from a poor family, why should I not get the benefit of reservation? Why should reservations be reserved for those who may well have economic advantages but are socially and educationally backward? Remember, Dr. Ambedkar had said reservation should be only for 10 years.
Yeah, see, there were two issues before the court. Issue one was whether on economic criteria alone you can have reservations. On that issue, all the 5 judges are in agreement. They say you can. So there is no dissent on that point. All 5 are in agreement on the first point. It is on the second point, which is of exclusion. So once you say you can have reservation in economic criteria, then to exclude on the basis of caste, backward caste, OBCs and SC, ST, is that permissible as per the basic structure? On that issue, 3 judges say yes, you can exclude, that doesn't violate basic structure. 2 judges, that is Justice Bhat and Chief Justice Lalit, say no, you can't. Now, there is, I think, a fundamental distinction between the first and the second issue, which for your audience is very important to understand. Once we have understood that bit, then going forward, economic criteria is not a problem at all. But how do you give it, even by the logic of the reservation of 103rd Amendment, which is that, okay, you identify the poor. So let us identify the poor, no difficulty. But once you identify the poor, despite the fact that the person is poor and he is in fact Dalit, You are denying him. So what the
No, but he's already getting, no, a poor, no, 1 minute, Shadan, a poor Dalit is already getting the benefit under the existing SC/ST quota. So why a general category poor person whose family income was less than 8 lakhs as per what has been defined has never got that benefit. Now he gets it, even if it's 10%.
See, first, Rajdeep, we should stop calling it general category, because in general category, even a backward caste OBC or a SC/ST can participate. That's the general category. What this category is a forward caste quota. Let us accept it. What was devised in the 103rd Amendment was for economically weaker section of the forward caste.
That's right.
It was not for general category. Okay. Now, if in that, so just because you are getting quota somewhere else, that is, what is the logic of this? That people are economically deprived. If despite the fact that your group has historically gotten quotas and the data was before the court, in fact, the very report which is the basis of this passing this amendment said that the SC/STs and the backward class are the poorest amongst the poor in India, despite having reservation for 70 years. So if that is the actual factual status of these groups on the ground, then where is the question of excluding them from a quota which they historically, because remember, if 50% they had access, in general they had full access. Now you have carved out 10%, which was earlier available to them, and you have excluded the backward class from this. That's why the dissenting judges have said that this is heaping further injustice on the already discriminated.